Good morning.
Good morning, Judge.
Good. Is everyone else on board? Miss Thomas Nkosi? No, Nkosi Thomas.
Good morning. Good morning, Judge. Morning, my lady.
Good. I finally get to see you. I remember you had a problem with your camera the last time.
Yes.
All right, good. Are we all on?
You very well, both you and our colleagues are learned friends, so it was a bit unfair.
Well, they say they save the best things for last.
Oh.
All right, so are we all ready to kick off?
We are indeed, my lady.
Good. Ms. Lani, I think you, as the applicant in this matter, will have to kick off. Oh, you're muted. I can't hear you.
Apologies, my lady. Can you hear me now?
Yes, I can.
May it please you, my lady, I appear on behalf of BEADICA in this application. My lady, as a starting point for this application, I think it is necessary to distinguish what this application is and what this application is not. My lady would have seen from the SIU's written submissions filed on the 25th of August that they contend now, or something that they didn't contend in their notice, but they have now taken the point that the application to stay is a belated jurisdictional challenge to the tribunal's jurisdiction. And in addition to that, they have also taken the view that the application is akin to an application to interdict and restrain not only the SIU's powers, but also the tribunal's powers. And my lady would have seen from the heads of argument or the written submissions filed that the SIU has spent considerable time and effort on these two propositions and arguments. My lady, those arguments would have been supportive had this in fact been an application challenging the jurisdiction of the tribunal, and had it in fact been an application interdicting and restraining the SIU's and the tribunal's powers. My lady, this is not BEADICA's case. The application before your lady is merely an application to stay the proceedings, the review proceedings, pending determination of the Constitutional Court's decision in the Letla matter. My lady, so for purposes of this application, my lady actually only has to have regard to two authorities that we have cited in our written submissions. And I will refer your lady to these authorities. The first authority, my lady, is the Supreme Court of Appeals authority. That's the matter of Caesarstone S.Yam versus World of Marble and Granite. And the citation there, my lady, is 2013 6 SA 499. The second authority, my lady, is the Constitutional Court judgment in the matter of Makone versus Tassos Properties CC and another. And the citation there, my lady, is 2017, volume 5, SA 456.
And that's a Concord matter.
That's the Concord matter, my lady. So the Caesarstone matter, the Supreme Court of Appeal matter, confirmed circumstances in which a court can exercise a discretion and under what circumstances a court can stay proceedings. And in that situation, the court specifically concluded that a court can stay proceedings pending a determination of a material issue in another court or in other proceedings. And the court said that this is a sensible approach. And I'm not going to deal with the merits of that matter, my lady, but the principle in that matter said that because there were different proceedings in another court that had a direct bearing on the proceedings before that court, it had the necessary discretion to stay these proceedings, as it would materially affect the outcome of the application before it. And my lady, that principle was recently confirmed, I say recently, 2017, in the Constitutional Court in the Mokone matter. And in that matter, my lady, the Constitutional Court had deliberated and had to consider whether it was in the interest of justice to stay proceeding, or the Constitutional Court had to decide whether the High Court, who acted as the appellate division or as a court of appeal.
In Mokone's case, the very material aspect which the court referred to was it goes to the core of the claim against Mokone, and that was the ownership of the property, because the validity of the sale was in issue. Yeah. I'm just not sure how that would be applicable here.
So, my lady, what had happened there was, because of the decision of the ownership of the property was a live issue and a material issue that was still pending in the magistrate's court, the Constitutional Court held that because this issue would be determinative of what had happened in the High Court, it might have a bearing on the ownership of the property and the appellant's right to actually evict Mokone in that matter. They said the High Court should have actually exercised its discretion to stay the matter, to stay the eviction proceedings in the High Court pending the determination in the lower court, because of the fact that it was such a material issue for determination. So, my lady, in this instance, and if we can...
Because that obviously, sorry to interrupt, but that would have gone directly to the locus standi of the party seeking to evict Mokone.
Exactly.
I'm just trying to... I'm just trying to see what we're taking out of it for the purposes of this case.
Yes, the purposes, or
what is, in other words, what is the live issue? What is the material issue?
The material issue, and I'm glad your ladyship focuses on that, because this is exactly it. The live issue in the current situation that we find ourselves in is the tribunal's jurisdictional powers. So the jurisdiction and the power to adjudicate, review, and hear review proceedings. That is a very live issue that is currently under consideration by the Constitutional Court. And that, my lady, we say, has a direct bearing. The outcome of what that court, the Constitutional Court, the apex court of this country, will decide, will have a direct bearing on what happens in this matter, my lady. Because if the Constitutional Court finds that the special tribunal does not have the powers or the jurisdiction to review administrative actions, then, my lady, the process before your ladyship would become, in effect, a nullity, or it would have to be transferred. So, whilst it is still alive before your lady and there hasn't been a pronouncement, there hasn't been a judgment in this matter, we're saying the sensible approach to take, and in line with the Caesar Stone approach, which is confirmed by the Mokone matter, the sensible approach in this instance, my lady, would be to stay the current proceedings pending determination of the constitutional issue.
Yes, thank you.
My lady, and perhaps just on that score where my lady said, well, because those parties, they were directly the parties involved, so there would be a direct consequence on what happens, because I see that my learned friend has also taken the issue and said all the authorities relied on by BEADICA substantiate the fact that basically an argument of lis alibi pendens. There's something that is pending before the court that is the exact same issue before another
And
court.
while we're just on that, before I forget, that is precisely the basis on which the Transnet matter was decided by this tribunal.
That it was lis alibi pendens. Exactly, my lady. And that is why the SIU has taken issue that we haven't said anything more about the Transnet matter. We haven't, but that is not the basis on which we bring this application to your ladyship. Basis for the application is the constitutional matter, my lady, the Letla matter. So we are alive to that fact, and we have not raised the issue of lis alibi pendens. We have raised the issue that the court or the tribunal in this instance has a discretion where there is a material issue for determination before another court to stay the proceedings before it pending determination. And it needs not be that it needs to be the same parties before the court, my lady. And in that instance, and I can perhaps just direct your ladyship to the Caesarstone, the SCA authority that I've cited previously, where the court then relied on Old English authority. And I think if I can just refer my lady to the correct passage there, if your ladyship can just bear with me.
Mm-hmm.
I think, my lady, it's at paragraph 66. Oh, apologies, my lady. No. Oh, sorry, my lady. It's paragraph 45.
Mm-hmm.
Where the court refers to the judgment by Milner J. in Cook, where he said, even if this does not strictly constitute a defense of lis alibi pendens, it is clear that the court may, in the exercise of its discretion in controlling the proceedings before it, debar a person from ventilating a dispute already decided against him under the guise of an action against another party. Although the previous proceedings had not even been between the same parties, the court held that for the respondent to attempt to retry an issue which had already been decided merely by changing the form of his action was an abuse of the process of the court. So, my lady, the authorities, and especially in Caesarstone, the court held, and that appears from the head note and the fly notes, to say, it does not mean it needs to be the same parties. It's not required that the same plaintiff sue the same defendant in both proceedings. So the court then exercised the discretion to see if it's the live issue, if an issue has one matter will have a direct bearing on another matter, it is still within that court's discretion to stay the proceedings.
Thank you.
My lady, the only test to be determined, or the only instance, and that comes from section 173 of the Constitution, which gives the court and the tribunal the inherent discretion, the only test to be considered is whether it is in the interest of justice to do so. And then in the same Constitutional Court judgment in McCorney, the court found that what is in the interest of justice is case specific. There is no set list of what constitutes what would be in the interest of justice. So in this matter, my lady, the interest of justice, we can summarize it as follows. Not only is it in the interest of the parties for this matter to be stayed, but in terms of legal fees, resources, the time of the court, and then also what would happen if it depends on what happens with the constitutional matter. If it is found that the special tribunal does not have the jurisdiction to adjudicate, there would obviously be severe consequences. Now, the SIU contends, and I will address your ladyship later on that the court has a discretion or can impose a restriction and a qualification to the retrospective effect. And we understand that, my lady, but for current purposes, that is in the court's discretion. It's not for one of us to determine what the court may or may not decide in these instances. So for purposes of this matter, my lady, the only thing that your ladyship should need to be concerned about is that there is a live issue, a material issue, currently under deliberation by the Constitutional Court. And the fact that the Constitutional Court has not yet given judgment in this matter, my lady, should be indicative that the matter is properly under consideration. If the Constitutional Court found that there was no merits in the propositions placed before them in argument, then the Constitutional Court would have already rejected and dismissed the application. They have not yet done so, my lady.
Well, again, we're assuming that the reason for that is
yes,
that it's being considered. And we also know from just being in this profession that the Concourt itself is overburdened in terms of work. So that may well be a factor.
It might.
I mean, we can make assumptions in that regard.
Yes, my lady. No, I completely understand. But be that as it may, my lady, the application, what BEADICA seeks is not an indefinite stay of proceedings. It's a temporary stay of proceedings. So the Constitutional Court, it has been before the Constitutional Court now for 3 months. In all likelihood, and like your ladyship just said, we don't know the burden what the Constitutional Court, but it is foreseen that it won't take an indefinite amount of time. At some point in time, they will come to a conclusion and a judgment. And pending that judgment, that is the time period that BEADICA seeks this application to be stayed, my lady. And it must be kept in mind that the application for stay will be beneficial for both parties concerned. The SIU contends to the contrary, my lady, but there can be no doubt that having certainty as to how to proceed with not only this application, but also applications of this nature will be beneficial in the long run. And will stop the incurrence of unnecessary legal fees.
Mm-hmm.
My lady, if I then turn to address your ladyship perhaps on the grounds of opposition as set out by the SIU in its, I would rather address it as it appears from the written submissions, my lady. As your ladyship would have seen, there has been some expansion. The SIU now also contends for the jurisdictional issue, which they did not initially do in their notice in terms of Rule 10.4. And the SIU has set out in a number of pages authority that they rely on. And my lady, as I stated at the outset, this would have been supportive of their argument had this been a substantive application to argue a preliminary point, being the jurisdiction of this tribunal. My lady, we are not here to argue the jurisdiction of the tribunal. If we wanted to do that, as the SIU rightfully said, we had to bring it, or we had to file it in our answering affidavit. And my lady, we did not. We're also not fighting this issue right in front of your ladyship right now. The fact that there's a jurisdictional issue being raised by another party, and that is still being determined by the Constitutional Court, is as far as the jurisdictional challenge is concerned in this matter. So, my lady, properly construed, this is not an application as contended for by the SIU of jurisdiction. Secondly, my lady, this is also not an application for an interdict, as I stated at the outset. The BEADICA has not brought a substantive application setting out the requirements for an interdict, because it does not seek to interdict and restrain the SIU's powers or the special tribunal's powers, my lady. The contention by the SIU that would have this effect, my lady, is also incorrect. If regard is had to the SIU or the actual powers conferred upon the SIU.
Well, I don't think that is the way I understand the point taken by the SIU, is that not that you have now specifically said, I'm interdicting your powers, you can't do A, B, C, D. What they say is it would effectively have that effect, because what would be the point now of SIU bringing these review applications? What would be the point of investigating all of this and do what with it? Because every party from here on out is going to, and until that Constitutional Court judgment comes out, every one of them is going to jump on the proverbial bandwagon. So in effect, what would happen is both the SIU and the tribunal cannot do the work that it is statutorily mandated to do. I think that is the way I understand that point.
No, that is the argument to that effect, my lady. But if one has regard to the primary purpose of the establishment of the SIU and what it seeks to set out to do, it's an investigating unit. So the first thing that the SIU needs to do is investigate malpractice, maladministration, anything from and I think if I can just perhaps look at the ambit of the relief, but the SIU's primary powers or primary reason for it being created is an investigating unit. Additional to that is the fact that they can proceed to bring applications to the special tribunal. And these applications aren't limited to review proceedings, my lady. The applications, there, and I think it's Regulation 5, civil proceedings. It can bring applications for interdicts, it can bring applications for forfeiture orders. Obviously, the forfeiture powers are also now the subject of constitutional scrutiny. It can bring action proceedings in terms of Regulation 5.1d, 5.2d for the recovery of losses. So, my lady, the principal powers of the SIU is in no way restrained if your ladyship is to grant a stay of proceedings. It can still conduct its business. There's nothing that prohibits it from, if the president is to issue a proclamation and to establish a certain SIU for a specific purpose, there's nothing to the effect that will restrain the SIU from exercising this power, my lady. And concomitantly, my lady, the same with the tribunal. The only effect that the stay proceedings, an order of a stay in this circumstances will be, is that this proceedings in front of your lady will be stayed. It's not a blanket interdict. It's not an interdict where we say suspend and interdict all the SIUs and the tribunal's powers pending the determination by the Constitutional Court. And that is where the difference comes in with the OTA judgment that the SIU relies on. In that instance, there was an application made for an interdict. And the court found there that the High Court, in considering that application, had to not only consider the common law requirements for an interdict, they had also had to consider how it would the separations of power, how it would affect the separation of power. And it's on that basis that the court criticized it and set it aside. My lady, this is not the circumstances which arise in this situation.
Mm-hmm.
So, my lady, in that regard, I would submit to your lady that even if there is an effect that the review function of the special tribunal is being questioned and that parties then bring applications to stay, it would be case specific, and obviously the courts would have to, or the tribunal would have to make a decision on each and every case, on each and every merit. Whether this creates some form of precedent, my lady, unfortunately, should have been within the contemplation of the SIU, being both a party to these proceedings as well as the LETLA application. Then, my lady, if I can turn to the other grounds of opposition, the unexplained delay in bringing this stay of proceedings. My lady, BEADICA filed a founding affidavit in support of this application, which they said, which was deposed to by the instructing attorney for BEADICA, in which she explains what had happened, that it was only in the course of preparing for this application or for the review application that it came to her attention and to counsel's attention that the LETLA application has still not, the Constitutional Court had not yet determined that issue.
Well, that's what I find remarkable, because that instructing attorney is involved in a number of SIU matters. And, you know, even laymen in this country are waiting for that judgment. So that I find remarkable, that it was only on the morning of the 15th that this came to the attention of an attorney who's so intricately involved in bringing matters or defending and bringing matters before the tribunal. It's something I'm finding a bit difficult to get my head around. Because it's been raised in so many different fora, you know, and how could an attorney not be aware of this and suddenly become aware, literally in the 11th hour before the hearing?
My lady, I can't take it further than what is in the application, but to say that, I mean, I can ask you, lady, to take judicial notice of the fact that where the parties are involved in certain SIU matters, it doesn't always have the exact same factual matrix. It doesn't have the same questions in law to be determined. So I understand your ladyship's concern, but the fact of the matter is, as soon as it came to the knowledge of BEADICA's legal representatives, steps were immediately taken to come to an agreement with the SIU. And your ladyship would have seen from the application as well as the letter addressed to the state attorney on the 15th, and the numerous attempts made between the council or to get hold of the council, as stated in the founding affidavit, that it was unsuccessful. BEADICA first attempted to come to an agreement with the SIU's legal representatives to stay the proceedings, but to no avail. And it was because of this refusal to stay the proceedings that this application had to be launched, my lady. My lady?
Just one moment. Sorry, yes, was that you, Miss Lani, or was that Miss Nkosi Thomas?
No, it was me, my lady.
Yes.
I just received instruction, and I just need to clarify for the record, my lady. I received instruction from my instructing attorneys that this is the only matter that they have in the tribunal relating to the SIU. So, my lady, that purposes, yes. So, just to clarify the position, this is the only matter that the instructing attorneys have in this matter, or have in this tribunal.
Yes, are there any further submissions?
Yes, my lady, the last submissions are just based on the basis of stay is unsustainable. That's the last grounds of opposition from the SIU. The first criticism is raised that all of the issues raised by the SIU in the main application in this matter is not the same issues raised in the Letla matter. My lady, I've already addressed your ladyship on the fact that the only issue of concern for both these matters, and that your ladyship can take into account, is the challenge to the jurisdiction and the powers of the tribunal to review and set aside administrative actions. And that is the paramount consideration and the material issue as defined in the Mokone matter as well as the Caesar Stone matter. Then, secondly, the SIU says that there's very little prospects of success in the Constitutional Court. on LETLA. My first submission to your ladyship would be that it is with respect not for the tribunal to consider the merits or the potential pitfalls, the procedural pitfalls of the LETLA application for purposes of this application. That is for the Constitutional Court to determine. The Constitutional Court is the only court in these instances that can regulate its own process, and as I've already submitted to your ladyship, Section 173 of the Constitutional Court provides just that. So, my lady, for that purpose, the demise of the LETLA application, as the SIU seem to classify it, does not matter in these instances. And perhaps I can just address this one issue, my lady, is the fact that the SIU seems to say that because both LETLA and BEADICA conceded to the jurisdiction of the special tribunal, that matter is now moot and it cannot now be raised. And for purposes of this, my lady, we submit that that is not an absolute bar. The fact that your ladyship would know that jurisdiction is obviously a legal issue, and the fact that there has been a concession of some sort for a legal point does not bar the court, and it's tried that it does not bar the court from finding that that concession might have been incorrect and setting that aside, my lady.
Well, you know, the practice of law, and especially with regard to jurisdiction, is once a party has submitted to the jurisdiction of a court, even where otherwise it would not have had, then you can't revoke that submission to jurisdiction. So that's what bothers me somewhat. Maybe you can address me on that.
Yes, perhaps I can refer your ladyship to the judgment in Matatile municipality and others.
Just give me a minute.
Sure.
Sorry, you say Matatiel. Is that in your heads or?
No, my lady, unfortunately, I have not, I did not include this in my heads, but I can send a copy to both my lady and to Ms. Nkosi Thomas.
Now, if you've got the citation.
I do have the citation. It is 2006, volume 5, SA 47, and it's a constitutional court judgment, my lady.
Thank you.
And my lady, in this instance, for current purposes, it must be borne in mind that the jurisdiction of the tribunal is linked to the powers that it gets through the Act. And that is where where it's a bit of a conflated issue. It's not just a jurisdiction in the sense of a monetary jurisdiction or a physical jurisdiction. It's jurisdiction specific to administrative proceedings. and the interpretation of the Act to confer these powers on the tribunal. So that constitutional issue, my lady, and if I can just perhaps refer your ladyship to paragraph 66 and 67 of Matatile. And in this instance, the court had consideration on concessions of a legal nature as opposed to concessions of a factual nature. And at paragraph 66, the following is stated. But it was conceded on behalf of the applicants that the procedures set out for the enactment of a constitutional amendment were complied with. The question is whether it is appropriate for this court to investigate whether the provisions of the Constitution were complied with in the light of this concession. As a general matter, a court should decide issues raised by the parties in their pleadings and in argument. They should not embark upon a judicial frolic and decide matters that are not before them. The adjudication of disputes between the parties is not an occasion to engage in academic exercise of deciding a whole range of issues that are not before the court. But, and this is where the court states, but like in all general rules, this too is subject to exceptions. It must yield to the interest of justice. And then at paragraph 67, the court goes on. Here we are concerned with a legal concession. It is tried that this court is not bound by a legal concession if it considers the concession to be wrong in law. Indeed, in a Zanian People's Organization versus the President of the Republic of South Africa, this court firmly rejected the proposition that it is bound by an incorrect legal concession, holding that if the concession was wrong in law, it would have no hesitation whatsoever in rejecting it. Were it to be otherwise, this could lead to an intolerable situation where this court would be bound by a mistake of law on the part of a litigant. And then at paragraph 68, my lady, it says, thus, where on the papers before it there is doubt as to whether a particular law or conduct is consistent with the Constitution, this court may be obliged to investigate the matter. So, my lady, the jurisdiction of the tribunal, and I would submit to your ladyship that this is one of those instances where it is exactly not factually on all fours, but definitely in terms of the principles that I've just cited to your lady. The powers of the tribunal is under consideration. Whether both LETLA and BEADICA conceded to the jurisdiction might have been an error in law or a legal concession that is incorrect. And that does not debar the Constitutional Court from finding that it was incorrect and investigating the issue.
Mm-hmm.
So, my lady, in those instances, I would submit to your ladyship that whether it is whether the constitutional challenge, whether the jurisdictional challenge is likely to succeed or not, like I said to your ladyship in the beginning, it's not necessary for this court to pronounce on those issues or for the SIU to contend for those issues. But if there is a consideration, my ladyship can take note that the Constitutional Court is now obliged to investigate this issue, which is very much alive before it. And then lastly, my lady, is just the SIU's contention that the court has a discretion in terms to order a just and equitable, or make an order that is just and equitable, which includes an order limiting the retrospective effect.
You mean its reference to the Concord?
Yes, yes, my lady, yes. Sorry. Where the SIU's argument to this extent is to say, well, even if we are correct, or even if LEDLA is correct, the Constitutional Court may make an order limiting the retrospective effects. And then it refers to the Executive Council, Western Cape legislator and others versus the President of the Republic of South Africa. Although that specific case had to do with the interim constitution, where it found pre-constitutional and post-constitutional law, it made a distinction to say, well, before our constitutional dispensation, there were obviously going to be a lot of legislation that might have been contrary to the Constitution. And for that reason, the Constitutional Court would have the effect of declaring it invalid, but then it has to have certain mechanisms in place to counter or to temper the effect. My lady, the submission is correct that there is that discretion for the court to exercise this. But because of the uncertainty of what could and could not happen, the speculative nature of what it is that is going to happen once the Constitutional Court finds this matter or make a decision on the tribunal's powers. What we're submitting to your ladyship is because of this specific uncertainty, the tribunal should rather stay the proceedings, act cautionary and stay the proceedings, and so as to get confirmation and a definite ruling as to how to proceed in the future. Because this is not an application that has yet been determined by your ladyship or by the tribunal. This is still pending. So for purposes of going forward, my lady, whatever the Constitutional Court may or may not decide will still have a bearing on this matter. And for that reason, we submit that it's premature at this juncture for the tribunal to hear the review proceedings. And the fact of the matter that this is also speculative, even on the SIU's own version, can be seen from paragraph 74.4 of the heads of argument. It is unlikely. The use of the word unlikely indicates that there's no definite confirmation as to what the Constitutional Court will decide or how it will exercise its discretion going forward.
Thank you.
My lady, if I can just perhaps just take a quick instruction from my attorney whether there's anything else, and then...
Certainly.
Thank you, my lady. Those are my submissions.
Thank you. Listen, Mr. Thomas, do you want to start now? Would you like a few minutes?
Well, a few minutes would be, if we could take an early tea break,
Yeah.
perhaps. If her ladyship is so inclined, that would be most appreciated, my lady.
Yes, maybe we could resume at 11:15. Is that enough, or 11:30?
11:15 would do. May
Good.
please.
We'll take the tea adjournment now then and resume at 11:15.
May
Thank you.
please, lady.
Ms. Nkosi Thomas, you may proceed.
May it please you, my lady, and thank you for the indulgence in relation to the early tea break. Maybe, perhaps we should start off with a housekeeping matter that our learned friends have raised. They are criticizing us, my lady, and they say that we have enlarged upon the points of law that we raise in the Rule 10, Sub-Rule 4. They make that submission or the complaint, as it were, at the back of them having brought us to court on an extremely urgent basis, my lady, having given us under 24 hours to respond to an application that they ought properly to have brought in May already. But be that as it may, my lady, our submission in regard to the so-called new grounds is that those are points of law that arise fairly and properly on the papers, in respect of which no prejudice has been suffered. They have not said anything about prejudice to your ladyship. So that complaint needed to be stated, only to be rejected, my lady, with respect. Thank you, my lady. Now, going right to the heart of the matter, my lady, it is so that the test ultimately is one of whether it's in the interest of justice for her ladyship to stay these proceedings in all the circumstances. Our lady, Leonard friends say that, yes, of course it is in the interest of justice. We submit otherwise. And, lady, we will start with the question that her ladyship properly put to our learned friends when they sought to rely on the Caesarstone judgment and the Mokoni judgment. Her ladyship put the question to our learned friend, but Miss Lani, what issue, what live issue are we to draw from these two judgments? Quite apart from the fact that they are distinguishable on the facts, they deal with a list of issue, same parties, same issues. That's not what we're concerned with here. But nonetheless, that question was put to Ms. Lani. What is the live issue? She then says to her ladyship that the live issue is the jurisdiction of this tribunal. She said court, but of course she was referring to this tribunal. She went further to say that a decision of the Constitutional Court in this regard will have a direct bearing on what happens to this case. She went further and said, if the outcome is that this tribunal does not have jurisdiction, the process before your ladyship would become a nullity. Of course, she's mistaken, my lady. The life issue, even if we were to accept that the jurisdiction of this tribunal is a live issue that arises in the matter that was argued before the Constitutional Court, that is not a live issue that is before your ladyship. Your ladyship will look in vain going through the papers for a live issue before her being in the name of the jurisdiction of this tribunal. Now, and her ladyship has been referred to Matatiele. We'll deal with Matatiele later on. But let's just make, first of all, please, our own submissions in relation to the submission point. At paragraph 45 on page 14 of our written submissions, my lady, we refer her ladyship to a judgment, hot of the press, as it were, of the Supreme Court of Appeal in the Advertising Regulatory Board, NPC, and others, versus Bliss Brands. The reference occurs at footnote number 24. This judgment we submit with respect that it's on all fours. Matatiele it deals with a different situation. And we'll deal with Matatiele in due course. Here, both parties appeared before a tribunal, a regulatory tribunal. At no point did Bliss Brands take issue with the jurisdiction of that tribunal. And of course, Bliss Brands lost somewhat and took the Advertising Regulatory Board, NPC, on review. The matter served before Her Ladyship, Madam Justice Fisher, who, with respect, I don't want to use the words judicial frolic, but she Meromotu expanded and enlarged upon the issues that were before her. And in so enlarging upon the issues, Meromotu introduced a jurisdictional issue. In other words, she went beyond the papers that were before her. She enlarged upon the scope of the issues and then found that the implicated tribunal did not have the requisite jurisdiction, having done so. The Advertising Regulatory Board, aggrieved by the finding of the court accord per Fisher J. Appealed to the SCA.
Sorry, did you say that the regulatory board agreed with the finding?
No, appealed to
the. Sorry, I thought you said they agreed.
No, they were aggrieved.
Oh, aggrieved.
That's right. Aggrieved by the finding, took it on appeal. That's what I.
Okay, good.
And then, of course, the SCA overturned the judgment of the court accord. But in overturning the judgment of the court accord, said two things that are important to our purposes, for our purposes now. At paragraph 9, writing for the SCA, Skeppers, I hope I'm pronouncing his surname correctly. Judge of Skeppers, many thanks, my lady. Writing for the court, emphasized that a court should decide only the issues before it, as pleaded by the parties. He did that at paragraph 9, and he relied, writing for the court, of course, on the judgment Fisher versus Ramahlele, footnote number 3, but it can be found in the judgment itself when Her Ladyship at her leisure considers it. This passage that he cites at paragraph 9 simply says that it is, maybe I should read it, it's so important. Should I?
Yes, please do.
May it please, my lady, I'm indebted. I don't want to tell Her Ladyship here unduly, but this is important. It is for the parties, either in the pleadings or affidavits, which serve the function of both pleadings and evidence, to set out and define the nature of the dispute. And it is for the court to adjudicate upon those issues. That is so even where the dispute involves issues pertaining to basic human rights and so on and so on. But ultimately, the court expressed its disquiet by the so-called enlargement of issues by the court of law in circumstances where the issue had been clearly defined in the papers. So the first principle, let's stick to the pleadings. What is before us? We decide those matters that are before us as defined by the parties in the pleadings. Remembering that the court of law had Meromotu raised a jurisdictional challenge, which it upheld, the court then said, because that jurisdictional challenge had not been raised before litis contestatio before the tribunal accord. First of all, it was impermissible for the court to raise it Meromotu and for the court to deal with it.
And this is what the SCA said.
This is what the SCA says at paragraph 13. This court has repeatedly held that a failure to raise any objection to jurisdiction and subsequent participation in proceedings is sufficient to demonstrate submission to jurisdiction. Then the learned judge continues. Bliss Friends, this is BEADICA in this instance, unquestionably submitted to the jurisdiction of the ARB. This is the Advertising Regulatory Board. Although the appeal now could be disposed solely on this basis, in other words, this is the end of the case as far as the SCA is concerned. It says because BEADICA in the case before us, or Bliss Brands before the ARB, because it had submitted to the jurisdiction of the ARB. That's it. That was dispositive. Although this appeal could be disposed of solely on this basis. So that's it. That's where the case ought to have ended. Then the learned judge continues. We were urged by counsel for the ARB not to do so, because the High Court's pronouncements on the constitutionality of clause 3.3 and so on may then others may create legal uncertainty. So what the SCA is saying there is that that's the end of the matter. I'm dealing with the rest of the issues just for the avoidance of doubt, so as to avoid uncertainty ensuing in the future. But it was incompetent for the court of law to have Meromotu raised jurisdictional challenge that did not appear, that was not pleaded. And the appeal, I'm happy, me being the SCA, to uphold the appeal purely on that basis. Now, how does that apply in our case? BEADICA has submitted to the jurisdiction of the special tribunal. So therefore, BEADICA, there is no live issue, going back to the live issue. The so-called live issue that arises in the Ledler matter does not arise here. So were this court to stay these proceedings, this court would be staying them, awaiting a judgment that is irrelevant to the matters that arise here. Therefore, it's not in the interest of justice to stay this matter based on a matter that is relevant to what we are here concerned with. Now, Matatiele. BEADICA says, no. The answer to the submission point, Matatiele, we made a concession wrongly. Therefore, we're not bound by that concession. Firstly, Matatiele is simply not applicable on the facts, but it's not correct to say that BEADICA made a concession of the jurisdiction of this tribunal wrongly. That is not correct. Because you say it's not correct because there's a plethora of judgments, my lady, but one of which being the Naderson judgment that I've no doubt her ladyship is aware of, Naderson judgment. Special SIU versus Naderson, 2002, volume 1, and so forth.
In your list of authorities, if I recall correctly.
It is indeed so on our list of authorities. So,
yes.
There, Harams J.A. writing for the court, it's paragraph 10. It deals with the scheme of the Act, the SIU Act. And then towards the end of this passage, he says the following: the tribunal consists of a judge and has, in general terms, the powers of a high court in relation to matters falling within the terms of reference. Then it continues to say that appeals lie against the judgment of a tribunal to the full court or to this court. So there it is. The SCA has made a pronunciation on this issue. And this, I'm afraid, this judgment is binding on the High Court and the Special Tribunal and so forth. So it can hardly lie in the mouth of BEADICA to state that, no, when we considered the jurisdiction of the Special Tribunal, we were wrong, we erred in law. Of course, they did not err in law. The SCA has pronounced on this issue. The Special Tribunal, drawing from inter alia this judgment, has ruled on this issue in cases such as Caledon. Her ladyship is aware of this judgment. There's Caledon by Mudiba J. There's Zakeni by Mudiba J. There's Ledla for that matter. There's a whole lot of judgments. So it was not, that concession was not made as a result of an error of law. There is judicial authority that buttresses that concession. Therefore, in conclusion on this submission, there is no jurisdictional challenge before you, my lady. So therefore, it's not in the interest of justice to stay these proceedings in order to allow the Constitutional Court to finalize the jurisdictional challenge that it is faced with. It's the first basis submission. And the second reason we submit that it's not in the interest of justice, my lady, is that when one has regard to this tribunal, this specialist tribunal. It was created for purposes of inter alia, granting speedy relief to the SIU on matters that arise from their investigations. Naderson tells us as much as well, my lady. At paragraph 13 of the self-saying SCA judgment. Haram's JA, as he then was, wrote as follows for the court. No doubt, the object and purpose of the act is to investigate allegations of corruption and fraud and to reclaim ill-gotten gains speedily. That's our emphasis, speedily, by the use of specialist bodies. The proclamation evinces the same underlying purpose. Now, the type of relief that this tribunal grants ranges from preservation orders, forfeiture orders, disgorgement, ill-gotten gains. In other words, the relief is akin to Mariva injunction type relief, as per the Knox DRC's line of cases. These forms of relief are inherently urgent, my lady, because it is well known that ill-gotten gains lend themselves to secretion half the time, such that the longer one delays granting the SIU relief, the higher the risk, my lady, the higher the risk of secretion, and therefore rendering the ensuing judgment hollow. That really is the scheme. The SCA has told us, paragraph 13 of Naderson. Now, where elected to stay in perpetuity, we're not even told stay until when. Well, maybe not in perpetuity until the Constitutional Court hands down its judgment, but we don't know when that is going to be. That would frustrate the scheme of the Act, that being to grant speedy relief to the organ of state on behalf of which the SIU acts in terms of Section 8 of the Act. So we submit that it's not in the interest of justice for this further reason. This second reason, my lady, is intertwined with the outer interdict rationale. There, we are being criticized, saying this is not an interdict, but that's just form over substance. And her ladyship put her finger right on it to say, we're saying the relief is akin to, it will have similar effect. And we know the law in that regard. That is not to happen. Outer has told us that a court should, as much as possible, refrain from interdicting the performance of a statutory obligation. So the specialist court basis is intertwined with the interdict analogy, my lady. Ultimately, it's about speed, it's about it's about discharging a statutory obligation, and that should not be hampered unless there is a clear case, and no such a clear case has been demonstrated on the papers before court. And there's also the Ledler issue. That's ground number 3 for it not being in the interest. And as far as the Ledler is concerned, really, the point that we make there is that Ledler's prospects are remote because of what we read to be a concession. But even if Ledler were to succeed, it does not follow that your ladyship's order would be a nullity, because the court can grant just an equitable relief, and your guess is as good as mine in terms of what the court would find to be just an equitable. But I don't see a court simply saying all the pending matters should be removed before the special tribunal, because I find that the special tribunal does not have jurisdiction. And this brings to mind cases such as Afri-Business. We cite Afri-Business in our heads of argument, where the court found that a certain regulation, Regulation 9, made under the BEE Act, was unconstitutional. But then the court didn't say, because I find this regulation to be unconstitutional, therefore all procurement in the country should stop. That's not what the court did. The court, in the exercise of its 172(1)(b) jurisdiction, issued an explanatory note, a clarification note, ultimately, finding a happy medium between the declaration of invalidity and the immediate consequences that could bring about prejudice to the administration of justice, as it were, and the public interest. So whereas the regulation has been found to be unconstitutional, its unconstitutionality has been suspended until February of next year, which means that it continues to be enforced, that regulation. So anything, even if Lindler succeeds, that does not mean that the tribunal is going to be stopped, as it were, from processing the matters that are pending before it. So, my lady, there are also, there's a whole lot of bases, and I don't want to detain her ladyship unnecessarily. Maybe I should just go to deal with this one as the last one and leave the rest to her ladyship. She will find them in our notice and in our written submission. There's just one last ground that I would like to emphasize. And I'm not suggesting that these are only grounds. We have a whole lot of them, but I'm just emphasizing the key ones. The one last ground that I wish to emphasize in buttressing the overarching submission that it would not be in the interest of justice to grant a stay is that this case, this BEADICA case, is based on common cause facts. On the papers properly construed, BEADICA has conceded to the unlawfulness of the impugned contract. A similar case, based on similar facts, was brought before this tribunal by the SIU, and the SIU has succeeded in the setting aside of the impugned contract and the disgorgement of the ill-gotten gains. Similar facts. So this is one such case.
Is that in your head? That case that you're talking about, I'm trying to... Is that in your heads, Ms. Nkosi Thomas? Maybe you can give me the reference to it?
My junior is looking, please, my lady. Then
sure.
I'll come back to it. So there's a Kenny judgment has been published, is out there, similar facts. So this is, we are constrained, my lady, to make the submission that this is a delaying tactic to avoid the inevitable, because we have already seen what happened in the Zakeni matter. And therefore it amounts to an abuse of the court process. And that gets aggravated by the fact that this application was brought in the 11th hour. We therefore request of your ladyship of this tribunal to express its disquiet against behavior such as this, not only by dismissing this application, but by ordering BEADICA to pay costs on an attorney and client scale. Are you succeeding with BEADICA? It's okay. Footnote, my lady, number 7, my junior says.
Number 8 is in relation to the jurisdiction.
So, my lady, at footnote number 8, there is a judgment there, unreported judgment delivered on 26 February 2021, Special Investigating Unit versus Zakeni Strategic Supplies. That's the case.
Okay.
It was argued in Feb, and judgment was delivered in June. I think there's a typo there. I apologize for that. That is the judgment. That similar facts. So this is a delay for the inevitable, and this court should express, as we respectfully submit, its disquiet. The rest of the basis on which we rely for the proposition that is not in the interest of justice are contained in our written submission. Some of them are contained to the extent that we have not addressed them fully on our feet. They will be found in our Rule 10, Sub-Rule 4 notice, my lady. At this stage, we are happy to take any questions if her ladyship has questions for us. Otherwise, those would be our submissions, my lady. We ask for order dismissing with punitive costs. May it please you.
Thank you, Ms. Nkosi Thomas. Any reply, Ms. Loni?
Thank you, my lady. Yes, I will keep my reply quite brief. The first aspect that I just want to address, my lady, is the SIU's reliance on the Nadesan case. My learned friend referred to that case, and in that case it was a SCA matter, and it's quite distinguishable from the current one because there the court held that it was a question of territorial jurisdiction, my lady, which I submitted to your ladyship is not the concern here. This is not an aspect where territorial jurisdiction is being questioned or being decided on. Here it goes inherently to the powers of the SIU and the Special Tribunal as it's reflected in the Act. So therefore, my lady, from that purpose, it's quite distinguishable on that score. And I think it's necessary to perhaps just read to your ladyship what was held by Judge Harams specifically. And if I can just read this for your lady.
So in the Nadesan judgment?
In the Nadesan judgment, yes, my lady. It's in the head note, but the relevant paragraph is paragraph 5 of the judgment, which can be found at 610 A to D. But as it was held, and I think I just summarize it as follows, my lady. So it says that units such as the appellant here, so like the SIU, are like commissions of inquiry, invasive in nature and liable to make inroads on the basic rights of individuals. Accordingly, they had to exercise their powers strictly in accordance with the statutory or other authority by which they are created. The appellant's reliance on a liberal, that is an executive-minded, construction was therefore misplaced. A tribunal under the Act, like a commission, had to remain within the boundaries set by the Act and its founding proclamation. It had no inherent jurisdiction, and since it trespassed on the field of the ordinary courts of the land, its jurisdiction had to be interpreted strictly. Now, my lady, that is exactly what is currently being questioned by the Constitutional Court, is the jurisdiction of the tribunal and the strict appliance of the Act. And my lady would have seen the arguments that was advanced on behalf of Letla, where it says that because the review powers aren't specifically given to the tribunal in terms of Regulation 5, that this must be interpreted to the effect that the legislature never had the intention to give the tribunal review powers. So, my lady, despite the SIU's contention that this isn't a live issue, this is the exact issue that is currently being considered, and it will have, no doubt, a bearing on the current matter before your ladyship. The second submission, my lady.
Just a minute.
The second submission, in response to my learned friend's submission that the SIU or the purpose of the tribunal as well as the SIU is to have matters disposed of speedily, because that is in the interest of justice. Now, my lady would have noted that the SIU has started out its submissions to your ladyship to say that this was an abuse, it's been brought at the 11th hour, it's a delaying tactic, and this issue needs to be resolved quite speedily. My lady, we have filed heads of argument in the main application setting out what we contend is dilatory conduct on the part of the SIU. I don't want to repeat all of that because that will be addressed if necessary in the main application, but just by way of example, my lady, I think the relevant paragraph is paragraph 8 of the heads of argument in the main application. And that sets out the chronology of how long it took for the SIU to institute these proceedings, which was approximately 8 months. And thereafter, how long it took for them to bring this matter to finality after not adhering to a lot of directives from the case management meetings held by Judge Mudiba. And not to mention, my lady, the consolidation application that was also brought at the 11th hour when the matter was previously set down for, and then also abandoned without any explanation. So, my lady, the submission by the SIU that this matter needs to be speedily determined should be seen in the light of their own dilatory conduct to date. And we submit that a temporary stay of these proceedings, given how this matter has unfolded to date, cannot be prejudicial to the SIU in any manner or form. And then lastly, my lady, just on the submission that my learned friend had made, and it's repeated in both the heads of argument in the main application as well as the heads of argument in the stay application, that this matter is largely based on common cause facts. My lady, that is incorrect. There is no common cause facts that would allow the SIU the relief that they seek in terms of the review application. And my lady would have seen that there was specifically, that's raised as a point in limine in the main application, the material factual disputes. So my lady, the statement that there's all common cause facts and that there is no defense and we're only doing this to delay the matter is factually incorrect. It cannot be said that this application has been brought frivolously. It cannot be said that it's been brought vexatiously. It concerns a material issue for determination, which would result in not only the SIU, but also the tribunal obtaining certainty on how to proceed in the future. And insofar as costs are concerned, my lady, I did not address your ladyship in chief, but my submission to your lady should be, or is, in fact, that the SIU, being the party, the common denominating party in all of these proceedings, which was both before your ladyship as well as before the Constitutional Court, was aware of this constitutional issue, or should have reasonably contemplated that this issue should be raised.
Yes.
This application was not brought before BEADICA's legal representatives made inquiries with the SIU and tried to come to some form of an agreement, my lady, which was not unreasonable given the circumstances.
Yes.
The SIU's refusal, on the other hand, my lady, we submit was unreasonable and necessitated this application before your ladyship. So, my lady, in light of those submissions to your lady, we submit that the SIU should be ordered to carry the cost of this application, which includes the cost of 2 counsel where so employed. Alternatively, my lady, and if my lady has regard to, and I think it's a well-established principle, it's the Buyer Watch principle that was raised by the Constitutional Court. I'm sorry, this does not form part of my heads of argument, but it's just in respect of cost, and I can give your lady the citation. It's 2009, volume 6, 232.
Concord.
Concord judgment, my lady, yes. Where the court said that if a constitutional issue is raised before court and the application has not been brought vexatiously or spuriously, that the court will be reluctant to order any cost to be awarded against the litigant where it involves an organ of state. So even if unsuccessful, the court would say that unless it can be found that an application is vexatious, that party should not be held liable for costs for raising a constitutional or an important issue concerning public consideration. So in that respect, my lady, I would submit that insofar as your ladyship wishes to make an order of cost, that the SIU be ordered to pay the cost. Alternatively, that this cost of these proceedings be stayed or reserved for a later period.
Thank you.
Thank you, my lady.
All right, now to some housekeeping. This application was set down for today, and the main application was then provisionally set down for Wednesday. The implication of that is that I must give a ruling by tomorrow so that we can decide what to do on Wednesday. It's simply not possible, you know, in light of all your submissions and things that I've got to seriously consider, for me to actually give a judgment tomorrow. I think that will be ill-advised. So we need to look at what's going to happen to the main application. I mean, I'm not sure if either of you has applied your minds to it.
not yet. We haven't. Not sure about our learned friends. Is your ladyship asking us to provide dates or?
Well, that's the problem. You know, I don't have an open diary as far as SIU matters are concerned or the tribunal matters are concerned. Later this week or at the end of the month, I revert to my High Court duties until the end of the term. So I'm not sure, you know, what you had in mind. If you want to consider it for a few minutes, maybe, and then let me know. It's going to take me, you know, a few days at least, in respect of time, you know, to be able to get to it. So I seriously doubt that I will be in any position to bring out a judgment tomorrow. But, you know, then that just leaves the main application hanging, and I'm not sure what is it that you know, what the two of you would propose be done.
My lady, if I may make a submission to your lady on that regard, I think if your ladyship, because I don't think either party wants to put unnecessary pressure, and like your ladyship rightfully said, it's an important. There's been a lot of submissions that has to be carefully considered. That would obviously have the effect that the main application cannot, it doesn't make any sense to determine how the main application is to proceed pending the termination of this application. So my lady, perhaps if there can then be the agreement that, I mean, until such time as we have your ladyship's directives or judgment in this application and then directives on how the other matter is to proceed, we can then call another case management meeting and then arrange a time for the main application if it is to proceed. Alternatively, if it is to be stayed, then the parties are no worse off.
Mr. Thomas?
My lady, the difficulty that we have, and I'm not sure whether there's a solution to it, as we submitted earlier, is that these matters are inherently urgent, and we would wish for the matter to be determined as expeditiously as possible for the reasons that we mentioned during our legal argument. So, and of course, we don't want to put undue pressure on her ladyship at the same time. Of course, another alternative could be for us to argue on Wednesday. And if her ladyship decides to goes along with BEADICA, then you won't have to rule on that. But if her ladyship is with us, then her ladyship would have had the benefit of the argument, and her ladyship would simply write a judgment that deals with both the stay and the merits. Because the time has been set aside, the matter is ripe, the heads have been filed, all the parties are available.
I'm not sure. Let me hear your thoughts on arguing the matter before I give a ruling in this matter, Ms. Lani.
My lady, I hear what my learned friend is saying in respect of the fact that the matter is ripe for hearing, and that's never been contested. The parties are ready, but by doing that, it's basically putting the cart in front of the horse to say, well, what we're saying to your ladyship is that there's prejudice insofar as costs are concerned, and we don't want to re-argue a matter necessarily. That would just defeat the entire practical purpose and the sensible solution that we've referred your ladyship to in terms of the case law. So that would also not be a practical solution, I would submit to your lady.
Because in effect, it would mean we have to adjourn the sine die.
Exactly.
That's the way I see it, until we get this judgment out, which I'm hoping won't be too long from now. But the practical effect is we can't leave the main application hanging. You do one of two things. You either adjourn it sine die, or we fix a date. Now, you know, for that to happen, and my ruling and hopefully the Ledla one will be out, you know, by that time. The question is when. At this point, I would have to confer with the president of the tribunal with regard to whether it should just be sine die or whether there's a date that can be fixed. But it cannot be before the new term. And so we're still looking at approximately a month and a half, to hear this. So that's the catch-22 that we have, let's assume I say no, it cannot be stayed. We still have to have a date, which is a few weeks into the future. So I'm not sure what you think is the best and most practical way forward. Either way, it would have the effect of a sine die adjournment. So maybe if it's adjourned sine die and I bring out the ruling in a couple of days, or let's say a week or so, then it's still open to the SIU to immediately enroll the matter for case management meeting and set down a hearing date, say early in the new term, or whenever it is that I'm going to be engaged again with the SIU matters.
Well, that sounds sensible. I think a sensible approach would be for a case management conference to be convened once the judgment has been.
Yes, I think that would probably be the most practical way forward. Good. Well, as I've indicated, I'm not going to be able to give you a judgment in the next few hours. So I'm going to reserve the judgment on this application. And instead of reconvening on Wednesday, I think we can just deal with the main application or the postponement of it now. So perhaps we could postpone that sine die?
Yes.
Okay.
My lady.
All right, and then on the understanding, of course, I'm not going to make it part of the order, but on the understanding that as soon as the judgment in this matter comes out, you will re-enroll the matter for case management hearing so that a date can be fixed.
Yes, we shall do so, my lady.
And costs will stand over in this matter.
May it please you, my lady.
All right, then the judgment in this matter is reserved. The main application is postponed sine die and costs will stand over.
May it please you, my lady.
Thank you, and thank you both for your comprehensive arguments. I think we can adjourn now.
Thank you, my lady.
Okay, we take the adjournment now.
Thank you.